good. Hey, Bill.
Okay, see is Joanne, but it's a nice scenery.
Yes, sir. Thank you.
My goodness, we're getting people now. Good deal. I'm going to get some coffee.
I don't think anybody knows that there's a hurricane brewing.
Oh, I bet they do.
Yeah, you can't get away from it. The news is your shadow.
Yeah. I'm going to email the dean as we speak. Okay. I'm going to mute myself.
So it looks like I've got 1, 2, 3, 4, 5 people. Good morning, Matt. I'm going to step out for a minute and I'll be right back.
Good morning. For those of you that just joined us, the empty chair will contain Bill Small in just a couple of minutes. Any questions while you've got me?
They still had you.
So everybody's doing okay with the program? No technology issues or anything? Okay.
So we've got 11 counting me and Joanne, so it's 9. Joanne, what's the maximum number that we have?
Oh, the maximum is, well, we have 25 in the class,
Okay, that's all I
but
was asking.
usually only about half can make it to the live sessions.
Right.
I would
So-
give it, I have 9:06. I would give it just a couple more minutes.
Oh, yeah, yeah. No worries about time.
Okay. Feel free to start anytime, Bill.
Yep, I just picked up one more, so
Okay.
definitely going to start in the next couple of minutes.
I'm going to mute myself, but I do have my phone, otherwise known as my leash. So if you need anything, text or call me on my phone.
Well, okay.
You want me to give you the number?
It's easier than looking it up.
Okay. 832-492-3942.
Okay. Thank you very much.
I may not be looking at the screen and listening the whole time, but I will have my phone on my person.
Okay.
All right.
Well, group, I think we'll go ahead and get started now. I'll start by saying this, and I'll say it a few more times. I really hope that you will have questions and that you have topics that you can raise and participate. It would be enjoyable. You really have a very rare opportunity here. You have the opportunity to ask a lawyer a question and not receive a bill. And I can tell you that down the road in your career, you'll appreciate how expensive it all is. But this will be an opportunity to ask legal questions, to discuss any topic you want to, that you would want to discuss with a lawyer. I'm a practicing healthcare lawyer here in Houston. I've been a lawyer for 49 years, and for 45 of those 49 years, I've practiced in the area that now gets called health law or healthcare law. When I started doing that kind of work, it was called representing doctors and medical businesses. And I've generally been on the individual physician and clinical side of things, although I do have an experience of having been a co-founder of one of the largest dialysis companies in the country, or in the world for that matter. And that was exciting as well. I see names of all of you. Feel free, I've got a big screen if you want to put your pictures up there. I'm fine with that. Kind of helps identify who you're talking to. I'm going to leave things the way they are. I am not heavy on technology, so I welcome any kind of suggestion or input that any of you may have that I'm sure most of you are more experienced in participating in and maybe even running Zoom conferences. I'm still a learner. I've still got my training wheels on for that. I thought it would be kind of interesting before we launch into just pure esoteric discussions of law, that we discuss a topic that is kind of overarching the health law space anyway. And I think you got a paper, I think Joanne sent it out or uploaded it to where all the documents are, called Healthcare Spending in the United States and Other High-Income Countries. This paper, and what we have is just a kind of an overview of it and a summary of it, but the full paper is quite extensive and very well researched. Commonwealth Fund is a private U.S. foundation whose purpose is to promote a high-performing healthcare system that achieves better access. It benefits from having about a $700 million endowment. So there's virtually no risk that any of the folks running Commonwealth are going to run out of money anytime soon. The reports of the Commonwealth Fund tend to be more respected and objective and not politicized. And those are characteristics that we really look to find to try to get trusted information. A study of why the United States spends so much more on healthcare than in other high-income countries concludes that higher prices, particularly for doctors and pharmaceuticals, and higher administrative expenses are prominently or predominantly to blame. U.S. policy must focus on reducing these costs in order to close its spending gap with other countries. And the one thing I'll add to that is to say that the spending level of the United States on healthcare is unsustainable. It will catch up with us at some point because we just can't keep spending upwards to 20% of gross domestic product on healthcare. Healthcare in the United States greatly exceeds that in other wealthy countries. But the US does not achieve better health outcomes. Policymakers commonly attribute this spending disparity to overuse of medical services and underinvestment in social services in the US. However, there has been relatively little data analysis performed to confirm that assumption. Writing in JAMA, Journal of American Medical Association, researchers led by former Commonwealth Fund Harkness Fellow Irene Papanikolaou and mentor Ashish Jha, MD, report findings from their study comparing the US with 10 other high-income countries to better understand why healthcare spending in the US is so much greater. By the way, if you have been watching coverage of the pandemic on television, you've probably seen Dr. Jha, who is, I don't remember which major network he's a consultant for, but it's either CNN or NBC or CBS or ABC, one of the major news forces uses Dr. Jha as a constant consultant about COVID-19. Well, the key findings of the study referred to are that the US continues to spend more on healthcare. In 2016, the US spent 17.8% of its gross domestic product on healthcare, while the average spending level among all high-income countries was 11.5% of GDP. Many of them were under 10. The US has lower rates of insurance coverage. While health coverage in the US has risen to 90% since enactment of the Affordable Care Act, every other high-income country has achieved a coverage for at least 99% of its population. The US has mixed levels of population health. While Americans smoke less than people in other wealthy countries do, they have higher rates of obesity and infant mortality. The life expectancy in the US is 78.8 years, nearly 3 years less than the average life expectancy in other high-income countries. Except for diagnostic tests, the US uses healthcare services at rates similar to those of other countries. Numbers of hospital visits and surgeries performed in the US are similar to those in other countries. However, the US performs 118 MRI scans per 1,000 people compared to an average of 82 MRIs per 1,000 among all other high-income countries. The US also performs a higher rate of CT scans, 245 per 1,000 people compared to 151 per 1,000 among all other high-income countries. The US pays for more doctors, or more for doctors. The average salary, and I thought this was really interesting, the average salary for a general practitioner in the US is $218,173, nearly double the average salary across all high-income countries. Specialists and nurses in the US also earn significantly more than elsewhere. The US spends $1,443 per person on pharmaceuticals compared to the average of $749, about 2 to 1. Healthcare administration, the US spends 8% of total national health expenditures on activities related to planning, regulating, and managing healthcare systems and services, compared to an average 3% spent among all other high-income countries. The study demonstrates that overall, health system performance in the United States does not compare well with that of other wealthy countries, particularly given high U.S. spending, a finding consistent with Commonwealth Fund's most recent health system rankings. The healthcare spending gap with other countries appears to be driven by the high prices that the U.S. pays for health services, particularly doctors, pharmaceuticals, and administration, compared to its peers. The U.S. has similar levels of spending for social services, including both public and private spending, and similar healthcare use, neither of which appear to be a major cause for the spending gap. To reduce spending, the authors of the report say that U.S. policymakers should focus on lowering prices and administrative costs rather than just reducing use of healthcare services. And what they refer to, or what they're referring to when they talk about people that are in control that can take steps to make changes, they're talking about essentially in the United States, a legislative process, because changes occur because laws change, which circles back to why this is a significant topic to talk about in an environment where we're talking about the law. Researchers analyzed data on healthcare spending, performance, and utilization made available by the Organization for Economic Cooperation and Development and the Commonwealth Fund from 11 high-income countries. That's what the study consisted of. Australia, Canada, Denmark, France, Germany, Japan, the Netherlands, Sweden, Switzerland, and the United Kingdom, and the US. Bottom line, the United States spends more on healthcare than other countries do because it pays more for healthcare services and administration. Anybody got a comment they want to make? Question anything? Have you read any of this before? I don't mean since it's been posted yesterday, I'm talking about just in general reading. Guess not. The other tangential paper that I had was the Obamacare repeal risk. No one is talking about nearly 1 million jobs. The healthcare reform bills currently under consideration in Congress pose one of the greatest threats to jobs in the US since the Great Recession. Of course, this predates COVID-19, which blew a hole in the jobs market and the number of people with jobs and the unemployed. There are more jobs in healthcare today than in the retail or manufacturing sectors. A big part of that story is the major increase in healthcare jobs with the expansion of insurance coverage under the ACA. Monthly job growth in healthcare since January 2014 is nearly 40% higher than it was in the preceding 7 years. How many of these jobs in healthcare will be lost if the House and Senate efforts to repeal and replace the ACA become law? After all, uninsured Americans use substantially less healthcare than their insured neighbors. A recently published analysis of the impact of the American Health Care Act, AHCA, passed by the House of Representatives from researchers at the Commonwealth Fund and the Milken Institute of Public Health at George Washington University predicts more than 900,000 jobs will be lost nationwide by 2026 if the House bill becomes law, which it did not. It got defeated. It was the last great legislative act of John McCain. This magnitude of job loss would mean rollback of nearly half of the healthcare jobs gained just since January of 2014. That would be devastating news for hundreds of thousands of healthcare workers with well-paying, often skilled roles who would lose their jobs. Many of them would also lose their own employer-sponsored health insurance. The analysis doesn't cover the proposed Senate version of the bill called the Better Care Reconciliation Act. A planned vote on that bill was delayed until after July 4th recess. This was in 2018, opening the door to changes. If the amended bill wins Senate approval, legislators will still have to work out a compromise with the House version. Bottom line is, this didn't happen, but it's really, what it does is it highlights a fact that really isn't taken much into consideration in terms of the war on the Affordable Care Act or Obamacare. Any questions?
I mean, this kind of tracks with my experience before the mandate was repealed, that, you know, I had a lot of patients who just anecdotally would mention to me, you know, the only way I'm really getting my care right now is because I was able to afford insurance through the ACA, or the ACA helped me out in somehow. And so if you take those people out of the pool who would be using healthcare, then you're taking dollars out of the flow into healthcare.
Absolutely correct. I mean, the ultimate irony is that there's this war on the Affordable Care Act, which, like most programs that provide benefits to people, once they get used to those benefits, they get attached to them. They don't want to give them up. And so the Affordable Care Act has gone from having a rocky launch to being very, very much liked, especially by the people who benefit, but by more than that, even by economists and bankers and investors, because it's helped bring some stability to the healthcare insurance markets. I wonder if even the insurance companies might not like it, but it's become a political football too.
Just kind of talking about both the articles you mentioned. Can you hear me okay?
Hear you fine.
Okay. I mean, the first one, you know, you're talking about massive increase or massive administrative costs and drug costs and insurance company costs and stuff like that. And you think about, you know, talking about the second article, the people who have jobs in those sectors, you know, it's easy to talk about healthcare reform, whether it be repealing the Affordable Care Act or, you know, Medicare for all or this or that. But I think a lot of things that don't get talked about is the massive unemployment you would see in certain sectors of the healthcare system if massive changes are made. You know, getting rid of private health insurance would get rid of tons of jobs in the private health insurance industry, you know.
No, that you're absolutely correct.
I mean, I think that's why they chose to go with the ACA and model it after the, you know, German and Swiss systems, because that way you're not going to single payer, you're not going to solely government run, but you're relying on keeping those insurance companies, but heavily regulating them and making them more competitive, because you're taking the power, like the market power, away from these very few large corporations and trying to spread it.
It's ultimately, I think we all probably would have to admit that a single payer system is what the future holds. Ultimately, it's going to have to be a single payer, but it's going to get to that point organically because we've had an insurance-based healthcare economy for many decades, and everyone has gotten used to it. Reeling it in, rolling it back, reducing the costs produces pain at every level. And it produces dislocation and unemployment and the requirement for retraining, and the million jobs that would be lost in healthcare as a consequence of repealing the Affordable Care Act would probably be a significant amount more than would be lost organically by going to a single payer system where the money was not available for all those jobs, and people figured out how to eliminate some jobs and consolidate and do more with less. Those factors always play out. What I think it's going to take ultimately is a recognition that healthcare is not a privilege, but is rather a right. And that seems to be the foundation for all of the countries, the list of which I read a minute ago, and many more, the developed countries, all of whose citizens rely on the fact that they have access to healthcare. And in America, if you know how to play the public health sector, you can get emergency health care, but general health care that keeps people from having a lot of those emergencies is still cut off to millions, even after there's been substantial closure of that gap to the 90% level under the Affordable Care Act, which is what the Affordable Care Act was designed to do. Anyone else? Okay. I've been doing these for a number of years, and at first I didn't start with the discussion of malpractice, but the reports that came in about, what would you like to change, or what would you like to improve, or what would you like to see more of, invariably started with, and oftentimes ended with, like to know more about malpractice. It's the great scare, because it's the horror of having to get tied up in court, lose a bunch of money. Everybody who practices medicine, whether it's at the physician level or the PA level or various other practitioners, all fear making a mistake or committing an act of negligence. So typically the groups that I've spoken before want to know more about malpractice. And so now what I do is I start out with malpractice and with general negligence law. So at the root of malpractice, there's this thing called a tort. And that's not an Italian food item. It is, in fact, an English word that comes from the Old English common law that means, in common law, is a civil wrong that is not a breach of a contract. So there's a standard out there that says you got to behave a certain way, and you violate that standard, and you cause damage, and you cause injury, and you cause loss of health or loss of money, that the claimant, you've committed a tort, and a tort in common law jurisdiction is a civil wrong other than breach of contract that causes a claimant to suffer loss or harm resulting in legal liability for the person who commits the tortious act. The person who commits a tortious act, including a doctor who commits professional negligence, is a tortfeasor. That's the terminology. And it can include intentional infliction of emotional distress, negligence, financial losses, injuries, invasion of privacy, and many other things. Those are all torts. Tort law involves claims in an action seeking to obtain a private civil remedy, typically money damages. So the most common result of a successful tort case from the claimant's perspective is the award by the court or a jury of money damages. Tort claims may be compared to criminal law, which deals with criminal wrongs that are punishable by the state. A wrongful act, such as an assault and battery, may result in both a civil lawsuit and a criminal prosecution, even though the civil and criminal legal systems are separate. We'll talk more about that later. Tort law may also be contrasted with contract law, which also provides civil remedies. That's when I say civil remedies, I'm talking about remedies other than being put in jail. After breach of duty that arises from a contract, but whereas the contractual obligation is one agreed to by the parties, obligations in both tort and criminal law are more fundamental and are imposed regardless of whether the parties have a contract.
Please, where are you reading this from?
Some notes of mine.
Okay, all right. It's not something you posted up for us?
No.
No, okay, gotcha. Thank you.
But I can have Joanne post up anything and everything, including these notes.
Okay,
And if you'd like, I'll assume that by asking the question, that would be something interesting for you, and I'll do it. Well, if you get bored reading it, just toss it.
thank you.
Sure. Tort law may also be contrasted with contract law, which also provides civil remedies after breach of duty that arise from a contract. But whereas the contractual obligation is one agreed to by the parties, where the parties negotiate and make an agreement, obligations in tort and criminal law are more fundamental and are imposed regardless of whether the parties have a contract. The parties may not have a written contract, but it's as though they actually contracted to engage in civil behavior, and one or the other of them began acting uncivilized and caused damage, and that resulted in an injury, and that would be a tort. The person who commits the act is called a tortfeasor. The victim of the harm can recover victims of such harm can recover their loss as damages in a lawsuit. In order to prevail, the plaintiff in the lawsuit, commonly referred to as the injured party, must show that the actions or lack of action was legally recognizable cause of harm. So it has to be, even if the act was against the law, it has to have caused the harm. That's what proximate cause is all about. Injuries are not limited to physical injuries and may include emotional, economic, or reputational industries. Reputational industries would be things like libel and slander, as well as violations of privacy, property, or constitutional rights. Torts comprise such varied topics as automobile accidents, false imprisonment, defamation, product liability, copyright infringement, environmental pollution. Compared to criminal cases, tort lawsuits have a lower burden of proof. That's because in the criminal law, the burden of proof in order to convict somebody of the violation of criminal law is beyond a reasonable doubt, which is very, very high standard. In civil law, and tort cases are part of civil law, the standard of, or the requirement for proof is that the proof only be beyond or by a preponderance of the evidence, that there's more evidence of guilt than of innocence, and therefore the conviction takes place. Compared to criminal cases, tort lawsuits have a lower burden of proof, namely preponderance of the evidence rather than beyond a reasonable doubt. Sometimes a claimant, this will kind of give you an eye opener. Sometimes a claimant may prevail in a tort case, even if the defendant who allegedly caused harm were acquitted in an earlier criminal trial. For example, O.J. Simpson was acquitted in criminal court of murder, but later found liable for the tort of wrongful death. After the famous or infamous criminal case involving O.J. Simpson, his former father-in-law, his wife's father, hired a lawyer and sued O.J. Simpson for wrongful death, which is a civil offense, and resulted in a very large damage award being awarded to Nicole's father, to the family. So now we talk about malpractice. And I think this is one that you've actually got posted. Medical malpractice occurs when a healthcare professional or entity, a hospital or clinic, harms a patient during the course of treatment. However, for this harm to constitute the basis for a medical malpractice claim, it must be considered negligence or practice that is not consistent with the standard of care. Medical negligence occurs when a doctor or other healthcare provider breaches or violates his or her duty of care to the patient. This duty of care, which is also known as the standard of care, will vary based on a number of factors, including the patient's age and specific health condition. The standard of care will also vary depending on the state the medical treatment is administered in. However, that's become less and less significant as a national standard of care has come into existence. The standard of care will also, this means that treatment for a specific illness in Texas might have a different standard of care from that in another state. Again, less significant today than that may have been 10 years ago. In most instances, though, the standard of care is determined to be the generally accepted methods used by other area doctors and healthcare professionals on similarly situated patients with similar conditions. In a malpractice case, there is what's called a statute of limitations. Statute of limitations is a legal rule that puts a limit on how long someone with a legal claim against another person can wait before making that claim. Bottom line, if you wait too long, you lose the right to bring the claim. Purpose of statute of limitations is to establish finality, that if you commit an act that's possibly negligent and somebody is damaged as a result, they don't have the right for the rest of their life or the rest of your life to bring a claim. Like all personal injury cases, the ability to bring medical malpractice lawsuits is governed by the statute of limitations. Statute of limitations puts a time limit on how long a patient can wait. Under Texas malpractice law, a patient who has been injured during the course of treatment must file suit within 2 years after the malpractice incident occurred. That, I'm going to contrast that so you can get a little perspective. If you breach a contract, and a tort is not as distinguished from a contract. If you breach a contract, the person that has been harmed has 4 years to bring a claim. The statute of limitations for contract claims is a 4-year statute. However, if the patient cannot determine when the incident that caused the injury occurred, the limit is set to 2 years after the completion of treatment or hospitalization. Because of the strict time limits on Texas malpractice cases, it's more likely that the claim will be filed within a short period of time following the incident. Damages tends to be the key issue in malpractice claims. If a medical malpractice lawsuit is decided in favor of the injured party, the plaintiff will be entitled to compensation or damages. Damages are money awards to compensate an injured party for the value of his or her injuries. These damages can take many forms, including economic damages, which reimburse the injured party for medical bills and lost wages due to missed days at work. And there's no limit on economic damages. They can also be non-economic damages, which include payment for pain and suffering. In some instances, there can even be punitive damages, which are meant to punish a healthcare professional who commits malpractice out of maliciousness. According to Texas malpractice law, there are caps that limit the amount of damage a plaintiff can try to get from the defendant. Texas places a $250,000 cap on non-economic damages. That's the kind that are normally called either punitive or for pain and suffering. But the cap is $250,000, and for hospitals, it's $500,000. The fact that this cap has been placed on malpractice damages has had a hugely negative or deleterious effect on the existence of malpractice cases, the malpractice lawyers bar, and access of people who are injured to legal remedies. Although many of these cases, the malpractice cases, settle, a typical claim will take years to resolve if it goes all the way to trial. Since the downside of a malpractice case is time, emotional trauma for the physician, and invasive nature of litigation in general, the threat of malpractice is still an important regulator of care. I think that you really, in order to get an idea of the specter, the current specter of Texas malpractice, you have to focus on the issue of tort reform. George W. Bush became governor of Texas in 1994, the same Bush that was president of the United States for 2 terms, for 8 years. One of the major promises that he made when he campaigned was to back legislation to limit damages that could be recovered in tort litigation in Texas. Before this time, Texas juries were known to award claimants huge sums of money for pain and suffering to punish the tortfeasor, the one that committed the tort. In Bush's view, the lack of limitation on tort damage recoveries was severely harming the Texas economy and the Texas business community. And basically, the Texas business community organized and was huge financial support for George W. Bush in his run to be governor of Texas and to be president of the United States. So this was like promises made, promises kept. Texas is a state now known for tort reform. As part of this tort reform, several limits have been placed on the damages those injured by medical malpractice can receive. Most notably, with a law that took effect in 2003, damages for pain and suffering are now limited to $250,000 in most malpractice cases. What has the damage cap resulted in? According to the Insurance Journal, since 2003, physicians' malpractice premiums have decreased by almost 50%. Texas has also seen a sizable increase in the number of physicians seeking licensure in Texas. While things may have improved for doctors, it is important to remember the malpractice victims. Most ordinary Americans cannot afford to pay an attorney out of pocket. Instead, attorneys take cases on contingency and receive a percentage of the damages recovered. Often this means no matter how valid the case, unless the victim can find an attorney who thinks it will be profitable, the case will never be heard. When the damages cap went into effect, the risk-benefit analysis for Texas attorneys changed. Medical malpractice suits can be costly to pursue with the need for extensive research and experts. Attorneys are less willing to risk paying the upfront costs for smaller potential payouts, which sometimes may not even recoup their expenses. In the end, this means fewer medical malpractice cases go to trial. Importantly, certain types of victims are also less likely to be heard. These are children, elderly, non-wage earning spouses. Why? Economic damages like wages are outside of the cap, but those individuals that earn little or no wages do not have the ability to recoup additional losses in this fashion. These are the hidden victims of tort reform, discussed in a recent study by the American Bar Foundation. But the bottom line is that for clients of mine that practiced orthopedics or OBGYN whose malpractice premiums were running $50,000 and $60,000 a year prior to tort reform, those same insurance policies now, the premiums are more in the range of $20,000 to $25,000 a year and less. And that's simply a reflection of the risks and the payouts and damage awards and malpractice claims. Tort reform has been hugely successful in Texas. Questions? Okay. In my syllabus, I've made arrangements. I've made time in each section in each of the 4 conferences for class Q&A and for you to complete your student assignments, or that's what I call them, within the time of each one of these segments. So we've pretty much come to the end of my part of the malpractice review. And it's almost 10 o'clock. And I am not going to start the contract section until 10:30. So I'm here for the free answers to your expensive questions. Any conversation you want to have about any topics in healthcare that concern you, or you're free to do the student assignment or just anything else you can think of.
Good morning. You had mentioned that the malpractice notes that you were just reading from were probably posted, but I was looking and didn't see any.
Then they will be.
Okay, thank you.
I thought that
I see quite a few. I see the PowerPoints for content section 3 and 4, and then
Oh,
there's
yeah.
quite a few other things like the ABA letter of intent, employee agreement, term sheet, physician agreement, recruitment, and stuff like that. So I see quite a few. It just that one was missing.
I thought that the malpractice professional liability in Texas was posted. I knew that Texas tort reform, the one that which is a kind of a jamming together of my notes and research. So that's not one you could find anywhere on the web. Either one of them, the professional liability, malpractice professional liability paper that I read from, or Texas tort reform.
Correct.
Yeah, okay. They will be uploaded.
Thank you.
Joanne does that. Anyone else? Okay, we will reconvene at,
In terms of malpractice, I'm an occupational medicine resident, so
I'm sorry?
sorry. I can ask the question at the beginning of the next session. That's fine too.
No. Now it's just fine. I couldn't hear what you were saying. You were going kind of fast too.
Oh, okay. So I'm an occupational medicine resident, and most of what we deal with is workers' compensation. So I understand that they kind of deal with, it's a little bit of a different breed. In terms of physician protections, where does that kind of fall in terms of malpractice and when dealing with workers' compensation?
The ground rules, as far as the commission of a medical negligence or professional negligence act, are essentially the same. Malpractice cuts through workers' comp. There's no special provision, but the damage awards for malpractice, even if it's in a workers' comp environment, are going to be as restricted as they are for anything else.
So if you work for a company like Shell or Exxon, the client can, I guess, come after both the company as well as you, or would they still be, going towards the physician?
I think that the problem, and I don't practice in this area, but I think that the problem would be that the party that delivered the care is the physician. The corporation didn't have anything to do with delivering the care, and in fact, it's illegal in Texas for a corporation to practice medicine. There's a whole line of law, common law and statutory law, that governs quote unquote corporate practice of medicine. So I think the physician is still in the gun sights as far as malpractice, but it's not as big a concern. Did that get anywhere close to your question?
Yes, I appreciate it. Thank you.
Okay. Okay, we'll start back up at 10:25. Talk about contracts. From a legal perspective, you're going to see more contracts than anything else that has any legal significance for the most part in a medical practice, whether you're in a medical clinical practice or you work for a hospital or some other organization. Contracts are going to be what you see for the rest of your career consistently. Generally speaking, in order to have a valid contract, you need to have offer, acceptance, and consideration. So you'll have a party that makes an offer, you'll have a party that accepts or modifies the offer, and you'll have consideration, which is what binds the parties together. Usually it's money. Take an employment contract for a physician. The hospital offers employment, the physician considers the offer and accepts the offer. That's the offer and the acceptance. And the hospital pays the physician a wage or salary. That's the consideration: offer, acceptance, and consideration. And one of the keys to remember is that in order to be valid as a contract, it does not necessarily have to be in writing. A contract can be verbal, but a contract that deals with real estate must be in writing. If you're doing any kind of a real estate transaction, whether you're buying a personal residence or buying a piece of dirt that you're going to put a professional office on, or anything in the middle of that, in order to have a claim under a contract, if it deals with real estate, it absolutely must be in writing. And that's true in all 50 states. The contract that comes to physicians probably the earliest in their professional careers is the employment contract. Most of you are looking forward to or already have secured employment. And generally speaking, it's been documented by the existence of a contract. The contract has distinct features. It certainly will contain the offer, the acceptance, and the consideration. But it'll also contain a lot of other terms that are part and parcel of the contract. For example, the contract, the physician employment contract, will contain a term. That gets defined as when the contract performance begins and when it ends, how it begins and how it ends. Typically, a physician employment contract will be for a term of 1 to 2 years. Although some can be for a longer term, it's difficult to arrange the ideas of a contract and to put them in writing with a commitment much longer than that, especially where it's a young physician beginning practice. One of the popular ways of doing the term of an employment contract is to have it automatically renew. So the contract would be for a term of, say, 1 year. If neither side says, I want out within 60 days of the end of that year, it automatically renews for another year, and so on. You can have that contract go on for many years, the auto renewal contract. I have a group of orthopedic surgeons I represent that have had automatic renewal contracts, and they've been in place with automatically renewing 1-year terms for close to 20 years for the oldest of them. So that's a popular way of doing the term. A major part of the physician employment contract will be taken up with the description of what the service requirements of the physician are. When you get your contract to review, read that carefully, because violating the terms of what the service requirements are can set you up for termination when you could have easily followed what the service requirements were, or if they were ambiguous, you could have gotten an explanation. So that language, even though it looks like it's just standard contract language, is important that you read and understand. Typically, the provision that gets most focused on in a physician employment contract is the salary provision. And the progression of salary in physician employment is typically that the first couple of years in a private practice setting, that is, I'll go to a hospital in a moment, but in the first couple of years in a private practice setting, typically the employee gets a set salary, a guaranteed salary, with an opportunity to earn a bonus depending on how hard the employee worked, basically. So salary and bonus is typically what you see in the early years of a physician career. Later on, the most popular format is one called Eat What You Kill, literally. And what that, of course, means is that separate records are kept about production, the number of patients seen, the number of procedures performed, the number of tests run. All of those factors determine the cash flow of all of those activities. And the physician contract typically contains a provision that enables the physician to collect a draw against the Eat What You Kill, so that and typically the Eat What You Kill transaction is one in which you get credited for the amount of cash flow that comes in for the work that you do, less your proportionate share of the expenses of the practice. And the difference is the compensation. Typically gets paid out in the form of a draw, and then the draws get reconciled every 90 days, every 60 days. And if the reconciliation results in a situation in which you haven't received all the compensation that you're entitled to, that's when you get the bonuses. And so that method of payment has become almost exclusive in private practice environments over the last 25 to 30 years. Probably the most controversial provision that can be included in a physician employment agreement is the non-compete. And they have become very popular, And just so you know, courts in Texas do enforce physician non-compete agreements. So if you've heard to the contrary, that is bad information. Normally, what will be required for a physician employment contract to have an enforceable non-competition agreement is that the non-competition agreement must be reasonable as to time and distance. The time would be how long after the employment ends can the physician not compete. And typically a term of 1 year is considered to be reasonable, and courts will reform agreements that have a longer period of time for non-competition, 3 years, 4 years, 5 years. A court hearing a case on the enforceability of a non-competition agreement can reduce the terms without invalidating the agreement. And so typically it's better to start off with something that's enforceable, that's reasonable, and a 1 year non-compete, 1 to 2 years, but really sticking closer to the 1 year is the most enforceable. The distance is, what is the area of the non-compete? Where can the physician compete and where is it restricted? What is the restricted area? If you're looking at Houston, probably if you have a restricted area more than 10 miles, it's probably going to be difficult to enforce. A 1 year, 10-mile non-compete, probably going to be fairly enforceable. One of the things that is absolutely required to enforce a non-competition agreement against a physician practicing in Texas is that the non-competition agreement must have a buyout provision. Has to be reasonable. Needs to approximate what the cost will be if the physician goes in competition with the former employer, violating the non-competition agreement. But in order to be enforceable in Texas against a physician, a non-compete agreement must contain a buyout provision. Often those buyout provisions will be 1 year's salary. That can run into some significant money. If the non-competition agreement is with an employee that's making $500,000 a year, and that employee wants to leave and go into competition with the former employer, that buyout provision is going to loom large in that decision. The theory behind non-competition agreements is that during the time of employment, the physician is receiving confidential information, proprietary information from the employer that gives that physician an advantage if they leave the practice and go into competition. And so it really, the purpose of non-competition agreements is to protect proprietary information, referral patterns, referral sources, methods and ways of increasing practice revenues. At least the employer is going to allege that these are all uniquenesses that the employee would not have been able to have access to except for the event of his or her employment, and they should be protected. And as I said, Texas courts do enforce non-competition agreements. Where a provision or two of a non-competition agreement may not be reasonable, they will reform those provisions and still enforce the agreement. Physician employment contracts will also include non-solicitation provisions where an employee can't leave a practice and take employees with them. Typically, that's not a big problem, but it's also a deterrent and a burden that the departing physician must endure or encounter and deal with. One of the subjects that's come up a lot in physician employment contracts and employment relationships that I've seen is, what are the rules when a physician leaves a group practice? And I don't know where any of you are in the parade of getting into practice and signing contracts, but if things work out in an employment relationship, these subjects don't come up. If they don't work out and the doctors tend to, the doctors are ready to split, and the younger doctor is going to go his or her separate way, there will be restrictions and regulations that may be recited in the physician employment contract about how the termination is going to take place. It's good to be aware that there is an agency in Texas called the Texas Medical Board that's actually looked at these issues and written some rules and regulations that have the force of law for situations where physicians are departing from a group practice. And so if this subject comes up, whether it's in conversation or it's part of your situation, you should be aware that you have certain responsibilities to patients when you leave a group practice. First of all, the group has a responsibility to provide the doctor that's leaving the practice with a list of that doctor's patients. And that list is defined by the medical board as patients that the physician has seen during the past 2 years. So it can be quite an extensive list. Secondly, the departing physician that's moving must communicate to that list of patients that they are leaving and where they're going. Now, typically that's something that the doctor wants to do and that the practice is really opposed to, but they don't have a choice. That's what the Texas Medical Board requires, and that's what you have to do. So the departing physician must communicate, send a notification to all the patients that he or she has seen in the past 2 years that they're leaving the practice and moving and where they're going and how to reach them. Can't be solicitous. It can't say, and for better medical care, follow me. That's a little brazen, but I run into stuff that brazen. But there must be at least a notice that of the departure, what the date of departure will be, when the new practice will be opened up, or the practice that the doctor is going to. And the patients have all the rights here. If the patient wants to follow a departing doctor, they can, regardless of what's been written in an employment agreement. So those are some of the high points of the physician employment contract. Does anybody have a question at this point?
Hello, thank you very much for your explanation. My question is, with the non-compete clause, does that pertain only to when you're going to open up a new practice or work in any practice that's near the one you previously worked at?
The non-competition agreement restriction tends to be written, for the most part, as broadly as possible. So the intention is to include every kind of practice setting that can be thought of.
Oh.
And I've seen some that were, and I think I'm right about this, mistakenly written restrictively so that only certain kinds of environments were prohibited. But typically, the way that they write, the way we tend to write these non-competition agreements, we write them in such a way that the doctor can't go into practice within the area and within the time. And that's defined as that competes with. So if you define something a restricted activity as one that competes with the employer, then it would be whatever the employer does, that you can't do that. And of course, that's exactly what you do want to do.
Exactly. Thank you for your explanation. In your experience, what do you think that is a time frame and a distance that really is of benefit for both parties?
Well, now you've asked a philosophical question, and I'm going to answer based on my philosophy. I said in the earlier presentation what I think is reasonably enforceable by a court. I think that for the most part, non-compete agreements are restrictions on free trade. And frankly, generally across the country, courts view them that way. That's the reason they get interpreted strictly. And in some instances, like in Texas, courts can reform them. But they try to stick pretty close to the basis, the stated basis for why the non-compete exists, what the benefit is, and so forth. They know that no matter how much language you put in an agreement, the employee is under pressure to sign that agreement, even if they don't like it. What do I think is reasonable? I think anything longer than a year is unreasonable, but I think less than a year is reasonable. I think competition is good. That's a philosophical point. And I think that the employer has very little proprietary property to protect, and that's what non-competition agreements are supposed to do. The classic example of a non-compete agreement is the Coca-Cola formula. When somebody goes to work for Coca-Cola and they're in a position where they could actually know what the formula is for the product, they have to sign a blood oath. You've never heard anybody say that this is based on the Coca-Cola formula, because that's how carefully guarded it is. That is proprietary information. If somebody actually went into competition with Coca-Cola using that formula so that the flavor of the beverage was identical to that distributed by Coca-Cola, that's a death blow to the company. So that's something that ought to be protected. If somebody was adept enough, it was skilled enough to develop a formula like that that's so popular, they deserve the benefits of that labor. And so again, that, I don't have a problem with that level of protection, but think about it. What is really unique about one medical practice versus another, including the marketing? There's just, it's almost a fiction. So the legal system has given fabric to it. And state legislatures have enacted laws that protect non-competition agreements in a lot of cases. In some cases, state legislatures have passed laws making non-competition agreements illegal in that state. I don't know whether they still do, but Tennessee used to be a no non-compete state. California was and may still be. That tends to be the case about California. So it's well to have it checked out. If you're getting a contract from an employer and it's got a non-compete agreement in it, that's a good enough reason alone. And I'm not blowing my own horn here, but it's a good enough reason alone to have somebody with expertise in these contracts review it and explain to you what you're getting into.
Excellent. Thank you very much.
Sure. Anyone else?
Yeah, I got questions. I guess to follow up on what you had just said. So my question was, as we get to start reviewing these contracts for jobs, I think quite a few of us are graduating this year. Do you advise seeking like a lawyer to take a look at it, or is it really just dependent on what's in there? I
strongly advise getting a lawyer to review the contract. Um, it's an expensive process, but it's well worth it, because there may be things in the contract that you would not read that a lawyer will read and tell you this is a potential problem. This is a pothole in the road, so to speak. And it might even affect your continued interest in going to work for that particular employer, whether it be a hospital or a private practice or just whatever type of employer it is. I would prioritize doing that. And there are ways of controlling the cost. You can make it real clear at the outset where you're dealing with a lawyer that you're not a bottomless pit of fees, and that it's, you know, what we want to do whatever is possible to keep the fees minimal. And if the lawyer that's reviewing your contract, you know, if you're going to go to Pennsylvania to practice when you finish your training, you don't want to hire a Texas lawyer to review your agreement, because they tend to be different from state to state, from area to area. So you want local counsel, and they're not hard to find, not with the internet anymore. And so you want to look for, generally speaking, a lawyer that specializes in writing and interpreting contracts, as opposed to litigating contracts. You don't need a lawyer that is going to have his or her expertise in litigation. And you want, if it's possible, and it is in most places now, you want a lawyer that's got experience in dealing with healthcare transactions, because they do tend to be different. Provisions in a physician employment agreement are going to be, especially the service provisions that define what your service requirements are. You know, a lawyer that has not done a physician employment contract probably thinks call is something you do on the phone. So just an example of that, it is an esoteric matter, and lawyers with that special expertise are available, and that's who you should be looking at.
Okay, thank you. The other question I had was, you had mentioned when leaving a practice, you notify the Texas Medical Board, as well as, you know, patients. I had actually read somewhere, and I was wondering what your thoughts on this were, and if it was true, that you should put an ad in the newspaper as well, because that is one way to kind of cover all your bases. It seems a little esoteric nowadays, but I don't know if that's still a law that's on the books or just a recommendation.
That's part of the Texas Medical Board rules that have the force of law. Putting an ad in a newspaper of general circulation is written into the rules. So yes, you have to do that. I didn't mean to imply that I was giving you all, you know, telling you all the different parts of that rule, but that's one of them. Another one is that you have to, that the practice you're leaving must post a notification in the waiting room of the office that you're leaving, and how to reach you, and what your final date of service is at the practice. That's all. That's part of the TMB requirements. You mentioned something that was not part of that. You do not need, you mentioned that you need to contact the Texas Medical Board or notify the Texas Medical Board. You don't need to do that.
Okay.
Texas Medical Board is not interested in hearing about these physician leaving transactions. They'd have to open a whole new division of the TMB, because there's thousands of doctors and there's a lot of moving around going on. The Texas Medical Board is the regulator, and here's the typical situation. You're leaving an established practice, and the CEO of that practice is a control freak and doesn't much care about rules and regulations, and you tell that CEO that you need a list of patients, and the CEO, don't you worry about list of patients, I'm notifying everybody. Well, that's not what's in the Texas Medical Board regulations. And so that's where conflict starts up with the doctor that's leaving who wants to abide by the rules, and the doctor who runs the practice that they are leaving doesn't care about rules and cares deeply about competition. So that's, frankly, that's about the level where you really need to get a lawyer involved. What I do with a situation like that is simply notify that CEO, I'll call him a rogue CEO, that my client is leaving his practice and the Texas Medical Board requires that these things be done, and I make demand that they be done. And if they're not, then you can complain to the Texas Medical Board, and they will take action, and the rogue CEO won't be rogue very long. One of the things that's happened in terms of just generally enforcing the adherence to regulations and rules, including standard of care and methods of practice, in the wake of the demise of medical malpractice, which was the regulator when damage awards were virtually unlimited. Now the Texas Medical Board has stepped up to fill a lot of that gap. And so you still can't get away with doing a lot of bad stuff with the Texas Medical Board around and accessible.
Got it. Okay, thank you very much.
Sure. Anyone else? I got to figure out where I was. There's a fairly significant difference between an employment agreement that you're going to see where you're going to work for a hospital and an employment agreement where you're going to work for a private practice group. Of course, things like the term and compensation and the ways of paying compensation will be pretty consistent. But where the private practice group compensation provisions are going to be pretty traditional, salary bonus, eat what you kill, those kind of things. Typically, that's not going to be the case with a hospital contract. Hospital contracts tend to be denominated in terms of things like relative value units, RVUs, that are set out in a formula in the contract. And so again, when you get somebody to review the contract and they see a compensation provision and they haven't done a healthcare contract, they haven't done a physician employment agreement, and they see this thing called RVU, they've got to get an education in healthcare before they can understand what that means. So that underscores the continued significance of getting a healthcare lawyer to review a healthcare employment agreement. Even though it's an employment agreement, it's highly specialized. Private practice employment contracts are going to probably be a little more negotiable than a hospital employment contract. And the hospital is going to justifiably say, every time we make a change in our employment contract, we have to go to the board of the hospital and get that change approved. So don't ask us to make many changes. Pretty much what you see is what there is. What you see is what you're going to get. There are some areas, nevertheless, that can be negotiated, and it helps to hire a healthcare lawyer to review in order to know what those provisions are. One of them that I've gone back and forth with hospitals on, and I don't think it's terribly well set even today, is the provision in hospital employment contracts that really basically permits the hospital to own 100% of the work product of the physician, regardless of whether work was done in off hours or on the physician's work schedule. By that I mean that if you're the kind of person who likes to write code and develop products, software products, or to do other kinds of engineering, or to develop a particular sort of medical appliance. If you like to do those kind of things and you conduct those activities at times when you're not working, when you're not scheduled to be working, be aware that your employment agreement with the hospital group may give the benefits of that work to the hospital, because it's part of your work product, and the hospital contract is going to say that the hospital owns 100% of your work product, and that you're basically an employee of the hospital. This is inferential, but it's pretty solid, that you're basically an employee of the hospital 24/7, 365. So anything you build or do or accomplish, other than doing scholarly papers and presenting them, if there's a stipend associated with doing that, typically that'll be an exception to the general rule that the hospital owns your work product. And if you weren't familiar with the fact that that is part of a lot of hospital employment agreements, you wouldn't know to look for it. But it is, and you should look for it. You may be subject to it. There may be nothing you can do about it, but at least you'll know what the terms of it are. Another form of contract that you'll see once you are established, you're in a private practice, you've been offered partnership or equity in the practice so that you become an owner. And besides just the documentation of your being awarded an ownership in the practice, the terms of that ownership will be governed by a contract. Contract will be, the parties to that contract will probably be all of the doctors that are owners of any part of the private practice. And the document that covers that subject is called a buy-sell agreement, or restriction on ownership agreement. Typically, this kind of contract establishes a market for a particular item of property, in this case, ownership in the medical practice, and it establishes terms under which ownership can change hands. And it can be very detailed, it should be very detailed. But at the very least, it'll cover what happens when a shareholder or member, those terms are interchangeable, dies, retires, gets divorced, becomes disabled. All of those contingencies or future events will govern how that doctor's ownership interest in the practice gets repatriated or dealt with. Because only a physician can own an interest in a physician practice in Texas, when a physician passes away, the interest in the practice has to be liquidated by the practice. So it won't be a case where the survivors of a deceased physician will be cheated. It's just that how they get handled, how the ownership interest in the practice is disposed of in the deceased doctor's estate will be described in the buy-sell agreement. That creates the market, and it creates the environment for the passage of ownership in the practice. Voluntary withdrawal, wanting to sell to a third party, all of those contingencies are covered in physician buy-sell agreements. And chances are, if you go to work for a private practice and you're there for a career, which sometimes happens. It's less and less as time goes on, but there are big, big groups that encourage longevity. In Houston, Kelsey Siebold is a good example. Medical Clinic of Houston is another good example of clinical groups that bring in young doctors and from which doctors retire. I've got a client that's a physician that retired from Medical Clinic of Houston. I met him when he and his wife came to Houston the first day they were in Houston, and they went to work. He went to work for Medical Clinic of Houston, worked a career there, and has retired. And most likely when I should say certainly, when he became an owner of Medical Clinic of Houston, this doctor entered into a buy-sell agreement, restriction on transferability agreement. And when he retired, his interest in the practice was bought out under that agreement. Another kind of contract that physicians will see frequently is a commercial lease agreement. Again, and much more so in the private practice setting. In fact, it would be unheard of in a hospital situation for a doctor to come in contact with the hospital's lease on their building, and the hospital may not even have a lease. It may be a nonprofit like Sisters of Charity, where they own property and they probably don't have an entity that even gets involved in leasing. But if in a private practice environment, the practice is going to, more often than ownership, it's going to lease space in which to conduct the practice and be, in that regard, be taking a look at a commercial lease agreement. There is a gulf of difference between commercial real estate and residential real estate. Just because they're both real estate doesn't make them similar. And so if you're going to be involved in a private practice and you are leasing office space, obviously you're going to get a contract from a landlord, and that contract is going to define all the terms of the lease of the space, the costs other than rent, assessments, rules and regulations of an office building. Those kinds of matters will be contained in a commercial lease agreement. Commercial leases tend to be for longer term. They tend to have larger security deposit provisions. They are different. In Texas, the real estate divisions or segments have been populated by fairly knowledgeable people with a lot of legislative restrictions. And so at least Texas tends to be a place where realtors give most of the advice in connection with either residential or commercial real estate. But it's important to know that people who practice in the real estate profession, those who are involved with commercial real estate, typically have no involvement at all with residential, and vice versa. Residential realtors don't have sufficient expertise in commercial real estate transactions and commercial real estate agreements to advise on them. So if you're going to develop a property or you're going to lease a property and you're going to be involved in a commercial real estate transaction, you should hire a commercial realtor, bottom line. Don't think the lady that sold you your house is qualified to represent you in the lease of your office space. That person may have somebody they refer to who is qualified, but if they're practicing in residential, they're not going to have the expertise to be able to advise in commercial. And if you're going to be leasing an office space or participating in the lease of an office space, you would need the commercial real estate experience, the person experienced in commercial real estate. Another common contract that you're going to see as a physician is what I call a partnership agreement. And a partnership agreement can be just that. It can be where people get together and decide that they're going to have a common business activity, whether it's an investment or it's a side activity to their existing business. And they know how they want to relate to each other. They form a partnership. Typically, that partnership is going to be some kind of a limited liability partnership. That could be a limited partnership. It could be a limited liability company. Could be a professional limited partnership or a professional limited liability company. But typically it's not going to be a general partnership. And if you take nothing else home from this course about any of these subjects, take home an aversion to being involved in a general partnership. If you get involved in a partnership, whether it's an investment, a medical investment, there's a lot of them, and a lot of them are really, really good. Even something as familiar as an outpatient surgery center or a dialysis center, if there's going to be an ownership group, make sure that the ownership group is not a general partnership. The problem with a general partnership is that if you're going to practice medicine and you're going to get involved in a partnership that's going to do something either tangent to the medical practice or different from the medical practice, that's not going to be your primary focus. In a general partnership, you're going to be exposed to all the liabilities of the partnership, 100%. Even if you're in a partnership that's got 10 partners and it borrows $1 million from the bank, if it's a general partnership, you'll be liable for $1 million, not the 100,000. That's what a general partnership is like. It's really something to stay away from. So sometimes those general partnerships are called just partnership. If you see the word partnership and it doesn't have a modifier, I'd be concerned that you're talking about a general partnership, something that you want to stay away from. A limited partnership is a corporate kind of entity, which I'll talk about later on this afternoon.
Thank you so much for giving us heads up on what to look out for. That's very helpful. Really appreciate that. My question for you is, would it be reasonable to ask the place you're going to work for to see their contract?
You mean their employment agreement?
That's right. To see if they do have that modifier, or, you know, what's their terms of agreement?
Oh. When you say to see their contract, you talking about their lease, their office lease?
No, we just talked about partnership. Partnership?
Oh, yep. If it's any kind of a partnership, if they're hiring you to be an employee, which is typical at the beginning of your career, then you don't have any liability as an employee for anything, any of the liabilities or obligations of your employer. You just wouldn't have that legal liability. You're signing a contract to either be an employee or an independent contractor. Generally speaking, it'll be an employee.
I see.
And as such, the law does not make you liable for the debts of your employer. Now, if you start investing a lot of money in the entity and you are involved in making decisions, in other words, if you cloak yourself in the garments of ownership and control, a creditor of that, if it doesn't work out, a creditor may be able to discover that you had a lot of control and that you really weren't just an employee, you were an owner. But as an employee, you don't have liability. Now, you can be an owner and an employee. If you're an owner under an employment agreement with the practice and you're also an employee, your liability for the debts or obligations of the practice would not arise under your employment agreement, but they would arise under your quote unquote partnership agreement. I hope that helped you.
Absolutely. Thank you very much for your explanation. Thank you.
Okay. Anyone else? No, so let me touch on a few more contracts. If you form an LLC, the governing document of the LLC is something called a company agreement. That is a contract. And that contract will be between or among the members of the LLC, the owners. And what they do in the company agreement is they basically constitute the business. They agree on certain rules and regulations, how often they'll have meetings, what kind of majority is required in order to be able to do business in a meeting of the company, what the meeting protocols are, notice requirements, all sorts of rules and regulations for the operation of the LLC. Essentially, the company agreement or operating agreement, those are interchangeable terms, are the constitution of the LLC. They establish directorship, officers, the rights of members, all of those kind of things, just like the US Constitution does for the country. That's what an operating agreement or company agreement, or sometimes if it's just a regular corporation, bylaws, they all do the same thing. They set up the business entity and they describe the rules and regulations for the operation of that entity. So I sort of saved the dessert for the last on my list of contracts that you're likely to run into. The one that I think most of you will run into more so than any other is real estate purchase agreement, because most of you are going to buy a house. And when you do, you're going to sign contracts that you almost will become invisible behind the mountain of contracts and the documents that you sign when you buy a residential real estate or commercial real estate property. But the residential has just gotten crazy with how many documents there are. Most of them are contracts. Here again, have an expert help you. And it doesn't have to, in case of commercial real estate, doesn't have to be a lawyer. In fact, it probably won't be. But the real estate agent that represents you is going to be well enough compensated that they probably are, if you convert the time they spent in representing you in your transaction into hourly rate, probably put most lawyers to shame. Be that as it may, an experienced realtor can really save you a lot in terms of the things you need to know to buy a residential real property. I can't ask for a show of hands because you guys are not connected picture-wise, but like in the live classes, I would ask, how many of you have bought a house? And a fair sampling of folks from the same kind of environment that you all come from would hold up their hands that they bought house and that they are represented by a residential realtor. Important, important, important. No matter what it is that you want, no matter how common you may think it may be in terms of that house that you're buying, make sure that it's written into the purchase agreement. The purchase agreement sometimes gets referred to as an earnest money contract because you put up a small amount of money to bind your offer, and that's called earnest money, and it's deposited in Texas. The earnest money gets deposited with a land title company, and they handle the closing of the transaction and disperse out all the money. But that agreement needs to have all the terms that you want, everything that you want to get. If you talk to the owner of the house, let's say it's not a new house, and you talk to the owner and you said, I want you to leave behind the appliances, the refrigerator, washer, dryer, and the seller says, that's fine. And the contract gets written up and there's no mention of appliances. All you've got is the goodwill of the seller, that they will leave those appliances behind, because if they don't, you have no claim. Got to be in writing. Suffice it to say that residential and commercial are very different from one another, which I talked about earlier. So does anybody else have a contract they want to talk about, want to ask a question about, an experience they want to share? If not, my voice is telling me that we need to break for lunch, which we're going to do, and we'll reconvene at, let's see what I've got here. Let's make it 12:30. Okay?
Thank you.
Thank you.
See you back at the farm.
I'm sorry, it skipped out. Can you say what time you said to be back again? Was it?
12:30.
Okay, thank you.
Okie doke. Is anybody out there? Joanne? Did I just get somebody to join me? Hello? If you're out there, can you hear me? Because I don't have my picture.
Yes.
Okay, that's Laura. Yeah, I screwed something up, but I'm still workable, but I can't tell who's signing in.
Hey, Bill.
I can see
Oh,
you
there you
too.
go.
Bill, if you click on the bottom where it says participants, it'll show you on the probably the right side of your screen who all's in there, who all's joined.
Oh, there it is. Okay, it's at the top on this screen.
Oh gosh, okay.
Wouldn't you know it?
Of course, of course.
Yeah. I can't remember how many I had before lunch. I think it might have been 10 or 11.
10. I'm thinking it was right around 10.
But that includes you and me.
I thought you had close to 10 without me. Now, keep in mind that if somebody is joining that wasn't here this morning, they're going to see 12:45 on that syllabus, so they may join late.
That's fine. We're going to start as close to on time as we can because I'm going to go pretty quickly. I may not even take the next break. Everybody is notifying of lockdowns and evacuations and all manner of stuff. And so for those of you who are waiting to start up again, I suspect everybody has things they need to get done before this storm, including me. And Joanne too.
Have you figured out if you're going to stay or go yet?
You mean Oh, we're not going anywhere.
Okay.
We stayed in town for Rita, you know, the whole city evacuated.
Oh,
And I mean, you could have played a game of football on Kirby Drive between San Felipe and 59.
I forgot you live further north than me too, so you're probably fine.
Oh, yeah. Yeah, I'm close to downtown Houston.
Joanne,
Yes.
I got that notification that they were closing the TMC campus and all that. Is that going to affect our class tomorrow?
Yes, it will. Well, okay, no, I take that back. I'm so sorry. It will not affect class tomorrow because, well, let me ask you, did you get that notice from TMC or from UHCL?
From UHCL.
Okay.
It said
I got it too.
So they're not closing
Tomorrow at
campus.
7:30.
Yeah, 7:30. They're not closing campus until 7:30. So we will go ahead and have class tomorrow. But you guys will probably finish kind of early. Y'all will start around 9.
7:30
And then-
a.m.
I'm sorry?
It says 7:30 a.m.
Oh, really?
It says
Mhm.
we'll close beginning 7:30 a.m. Wednesday, August 26th.
Oh, I'm
Right.
so sorry. I misunderstood. I thought it was 7:30 p.m.
No.
So, okay. We will not have class tomorrow, and I have already emailed my dean to find out how we will decide or how we will communicate to you guys when those last 3 classes will occur. So stay tuned. I know we're not going to meet tomorrow, but thank you for clarifying. I know we're not going to meet tomorrow, but not sure when we will reconvene.
Thank you.
Yeah, Joanne, just if it's helpful at all, in the notice, let me see if I can find that notice real quick that I got from UHCL. Yeah, here's what it is. Due to Hurricane Laura, University of Houston Clear Lake, including Pearland and TMC locations, will close beginning 7:30 a.m. Wednesday, August 26th. University administrators are continuing to monitor the weather and expect to reopen for normal operations at 7:30 a.m. Monday, August 31st.
Right.
Upcoming enrollment and payment deadlines will be extended at least 3 days. Continue to monitor. We've got a web address and UHCL social media for future updates.
See, our class ends on the 28th. So,
Oh, my
so
goodness.
I'm not sure how that will, how we will proceed.
Yeah, I don't think any of those defined terms have much meaning right now. I mean, the storm sort of takes precedence, but that's why I was saying I'm going to run through this pretty quickly. And I know that everybody's starting to think about, what do I have that's exposed? I mean, if you've got stuff sitting outside and we're going to get 70 or 80 mile an hour winds, which would be way less than what they're forecasting the storm to end up being, all that stuff becomes missiles.
Now, keep in mind, most of you guys live around the medical center, don't you?
I do.
I do.
So y'all won't get as much of the wind as on the coast.
That's for sure.
Closer and closer to the shore. Okay, I'm just curious, have any of y'all been through a hurricane before?
We sure have. Or I have. I've been through Harvey, Katrina, Ike.
Oh, gosh.
I
Okay,
can
well,
check all those boxes.
Yeah.
How about Alicia? Is anybody that old?
I remember it.
1983.
Yeah, I remember it. I wasn't in Houston for it.
I remember standing outside in my front yard and looking at the absolute blue sky in the eye of the hurricane.
Isn't that amazing? I've done that
It's just-
before. Yeah,
Yeah.
it's amazing. Okay, well, I'm going to,
Joanne,
yes, ma'am.
Do you mind sending out an email to the class just to clarify, so we all know that we don't have class tomorrow? I saw the
Absolutely.
email, but I know some people think we're online, so maybe we still need to be around.
Yeah. I was planning on sending something out. I was going to wait to hear from the dean to see how we're going to proceed, but I think I'll go ahead and send something out that says, so we know we're not meeting for class. Further details to come. I'll send something like that.
Thank you.
You're welcome.
Will we be able to make it up, do you think?
I'm just not sure yet. I just don't know.
Great, thank you.
I'm sorry that's not the answer you want to hear, but I just don't know. And I don't want to guess. But I will be in communication with you guys for sure.
That's perfect, thank you.
Mhm.
Okey doke.
I'm going to mute myself now if there's no other questions.
You stand muted or sit muted. Okay. I guess everybody was hearing all those conversations going on. So what I'm going to do is I think I'm going to go through the slides for conference 3 and conference 4 and then adjourn so that you guys have as much time as possible for personal needs, which I suspect may have some effect from the storm. So the first slides I want to do are based on origins of law and the taxonomy of the system of laws. The principal sources of law in our legal system are the Constitution, statutes, which means written laws that come out of the legislature and are signed into law by the executive or the president. And then administrative law, which are regulations, and then judicial decisions, which are what's called the common law. Those are the decisions of appellate courts on points of law, so that the decision becomes law. The Constitution is the foundational document of American law, and it's controlling in its language of the existence and correctness and constitutionality of all law that arises under it. The Constitution basically takes what was 13 colonies that won their independence from England and creates a structure to operate those 13 colonies as a single country. There are essentially two separate systems of legal governance in our country. You've got the federal system, which covers the entire country, all the citizens and persons in the United States. And then you've got the state system or the state systems of government. Each state in the United States, all 50 states, has its own constitution, has its own statutes or written laws that are passed by legislatures of those states and signed into law by the governor of those states. So it's sort of like a reflection of the federal structure. And each of the 50 states has its own court system, so that you've got layers, you've got trial courts in the state, you've got appellate courts in the state, you've got Supreme Courts in the state, and then you've got federal trial courts, federal appellate courts, and the U.S. Supreme Court. The design of our government by the founding fathers is for there to be 3 independent branches of government, and for no one branch to have absolute sway over either of the other 2 branches. The 3 branches being the executive branch, the legislative branch, and the judicial branch. The executive branch consists of the president, his cabinet, and all of the appointees that go into the executive branch of the government. The legislative branch of the government consists of the United States House of Representatives and the United States Senate. And the reason for there to be two different houses of the legislature, the House and the Senate, is to try to compensate for the country having a federal government and having a lot of people, a lot of units of the country, a lot of the original states that were very, very rural and had very little population. And so if everything was decided on the basis of majority rule and had one house of government like the House of Representatives, the more populated states would hold control over the less populated states forever. The Senate tends to make up for that because every state has 2 senators. So in terms of power in the Senate, Montana's as powerful as New York because each of those states elects 2 senators. And that compensates for the fact that based on population, New York has 10 or 15 times the number of United States representatives as Montana does, just using that as an example. The system of government that the founders set up was one called checks and balances, where powers of one branch of the government to control the other branch of the government were offset by powers for the other branch to control the first one. And probably the best known of the checks and balances is the executive veto. That is, that the President of the United States can veto any piece of legislation that comes to him for signature that requires his signature, and therefore declare the work of the legislative branch that brought the executive the law to sign, deny that power and to check that power where the executive feels that it's appropriate. Then there's another check in the veto, and that is that where the executive can veto the legislative branch and deny the legislature the law that it wanted to pass, the legislative branch can override the executive's veto by a vote of 75% of the senators, the legislators, both houses actually, and pass the law notwithstanding the president's veto. Doesn't matter if the president doesn't have a veto if the majority is big enough to override the veto. And so that's just one example. There are examples in the judiciary branch can control the legislative branch by declaring laws to be unconstitutional. Supreme Court does that all the time. There's executive powers to appoint. So there's lots of, the legislative branch has checks over the judicial branch because appointees to the federal judiciary have to be passed by the legislature, even though they're appointments of the president. So you've got a lot of those checks and balances, which is what this slide depicts. The structure of the legal system of the United States, and this is at the federal level, is the Supreme Court at the top, the courts of appeals underneath, and the United States district courts, which are referred to in the blue boxes as TC, which means trial courts. So cases that come before the federal court system that require a jury verdict or that where the parties want to try the case to the judge, but it's a federal case, all of that originates in the federal trial courts, of which there are multiples in virtually every state in the country except the least populated. And we've got United States District Courts for the Southern District of Texas, the Eastern District of Texas, the Northern District of Texas, the Western District of Texas. Is at least 4 federal courts in Texas. I think there's actually 5. Cases that are tried in those trial courts by the federal judiciary where a party is dissatisfied with the outcome and has the right to appeal, get appealed to the United States Court of Appeals. And that Court of Appeal, it'll be whatever Court of Appeals is geographically most proximate to the district court which the case came out of. In the case of Texas, where you've got a trial court decision or a district court decision at the federal level that's made in Houston or Dallas, that case would be appealed to the United States Court of Appeals for the Fifth Circuit. And that Court of Appeals sits in New Orleans. If either side is able to appeal a Court of Appeals decision, that appeal is to the Supreme Court. And the Supreme Court has original jurisdiction over some other matters. So that's kind of the 3-part structure. And the state of Texas has something that looks pretty similar to that structure, where it's got the Texas Supreme Court, the court of, in case of civil cases, because civil and criminal are split in the state, they're in the same system in the federal government. So the district courts, the federal district courts hear criminal cases and hear civil cases. In Texas, the Court of Civil Appeals hears appeals of civil cases, and the Court of Criminal Appeals hears appeals of criminal cases. And then the Texas Supreme Court hears appeals from the Court of Civil Appeals. The Court of Criminal Appeals is the highest court in Texas for criminal matters. And in Texas, the court of original jurisdiction for the biggest volume of judicial matters is the the district court. Every county in Texas has district courts, district judges. Some of the larger ones have district courts that specialize in certain matters. For example, in Texas, we have district courts that hear only probate cases, cases involving estates and deaths and so forth. And those would be called probate courts, but they are district courts. That's true here in Houston. Also in Houston, there's a tremendous volume of family law. And so there are district courts that are called family courts, and they hear nothing but family law cases. Divorce, adoption, all manner of family law cases are heard in the family courts, which are district courts. So that's just kind of a snapshot. Here's kind of a look at the taxonomy of law. You basically got 2 different kinds of law that relates to human behavior, if you will. You've got civil, which are affairs of one person against another person. And then you've got criminal, which are affairs of the people at large, the state of Texas, the United States of America. And those in cases, offenses are violations of criminal statutes, let's say federal criminal statutes, like we're hearing so much in the news. Those cases, the style of them is United States of America versus Paul Manafort, or United States of America versus Michael Cohen. And the list goes on. But if they were crimes under Texas law, if it were that Paul Manafort had violated a Texas bribery statute, it would be the state of Texas versus Paul Manafort. And that's the reason why all the lawyers who represent the city of Houston, the state of Texas, the United States of America, the state of Kentucky, what have you, all the lawyers that bring those cases as complainants are government lawyers, whether they're federal government lawyers or state government lawyers or local government lawyers. You've got City of Houston versus Joe Smith, who violated parking regulations 100 times over a 2-year period. And that would be, those cases would be brought by a city attorney. Maybe that helps explain some of the news stories that you see. And then I kind of sneaked this slide in, doesn't perfectly match the subject matter, but I wanted to talk about it with you because it's something that's so practical that all of you are going to see it. These are the structures, basically the major structures of business organizations. You've got unincorporated businesses like a sole proprietorship, and a sole proprietorship is exactly what it sounds like. It's a simple business arrangement where a person is in business under their individual name or an assumed or fictitious name, and they don't have partners, they're not a partnership, they're not a corporation. And typically medical practices where doctors go out and solo and don't see a particular need to incorporate, those medical practices, a solo medical practice would be a sole proprietorship. Now, and for many years, there were no statutes that permitted doctors to incorporate their practices, to form professional limited liability companies or professional association or professional corporation. None of those existed 35, 40 years ago. And so by definition, virtually all of the medical practices were sole proprietorships. They would sometimes become partnerships, but liabilities and things of that were all the same. But now we're operating in a much more corporate environment than at any time before in history. And so virtually all healthcare practices, healthcare businesses, and businesses in general are incorporated. The primary benefit for incorporation is limited liability. That is, as long as the corporation is kept up, as long as it is the party doing business, and it's not just an alter ego for its owners, but it really has its own identity, its own phone number, its own address. It's filed and registered at the Secretary of State's office in Texas or whatever other state it may be organized in. The business entity of a corporation will be what people organize under, and it'll protect an individual. If you, over a period of, let's say 20 years, you accumulate a couple of $1 million and it's been paid out to you as income or salary from your business or your practice and duly invested, that becomes a personal asset. So the corporation that you're doing business under, that is your practice, Mary Smith MDPA, has a huge, back in the old days, let's say, has a huge malpractice judgment taken against it. And actually, malpractice judgment is not a good example. Let's say that some heiress or foreign king or queen comes into the doctor's office and slips and falls and hits his head and dies of a brain hemorrhage. And the slip was attributable to the office floor being too slippery, and a $10 million judgment is taken against the corporation. We're not talking about malpractice now, we're talking about a slip and fall. And the poor doctor's got a couple of $1 million and was going to retire on that. By being a corporation, the $8 million negative, that is the judgment cannot be taken against the doctor's $2 million that he's got in the bank because he's protected by his corporation. What professional corporations also do, and why it's important for doctors to be incorporated, is they shelter the doctor from the liability for his colleagues' work. So if you're in a two-person practice, the other person commits malpractice, you don't have any liability unless you actually participated in the case and assisted in the surgery or other treatment, consulted. But chances are you didn't do any of those things. And so therefore, by being incorporated, you would not have liability for that colleague's mistakes or negligence or gross negligence. Questions, anyone? Let's see.
I have a quick question. Is the protection the same thing as being under the umbrella? Or
Say again, I didn't hear you.
is the same thing protection as being under the umbrella protection?
Well, I think you're probably referring to using the word umbrella in the context of insurance.
Oh, okay. So it's not the same kind of protection.
No, I mean, it's a separate issue completely. The insurance, I'm assuming in the example of the very wealthy person that got a $10 million judgment, that the doctor, let's just say, didn't have insurance, that there was no malpractice insurance at all. And if the doctor was incorporated, then the corporation would be liable for the $10 million verdict. And since the corporation probably isn't worth but a few $1,000s, even though that wealthy person had a claim or even a judgment, they couldn't collect it against the doctor individually because of the corporation.
Great, thank you.
Sure. Bear with me here. Okay, I'm going to run through these slides and talk about waste, fraud, and abuse. That's the hottest topic in healthcare these days, primarily surrounding two different laws, one of them called the Stark Law and the other one called the Anti-Kickback Statute. There's actually a third waste, fraud, and abuse law that's not cited as often as the two that I just did, but known as the Federal Tort Claims Act. And that's the first one that we'll talk about. So why is fraud such a big deal? Well, the answer is because money. Healthcare consumes, as I showed this morning, about 18% of our gross domestic product in a $20 trillion economy, which the United States is. And if 10%, which is what's estimated, of the cost of healthcare is tied up in waste, fraud, and abuse, you're talking about something close to $2 trillion or $200 billion being the target for federal regulators to try to get on top of the waste, fraud, and abuse in healthcare. The laws that protect or that govern and control the practice of medicine, the violation of which is healthcare fraud, are the False Claims Act, the Anti-Kickback Law, Stark Self-Referral Law, HIPAA, the Balanced Budget Act, and elements of compliance plans to address in the hospital setting. Under the False Claims Act, somebody violates that act by knowingly presenting a false or fraudulent claim and using a false record or statement to get a claim paid. Critical thing is it's a criminal statute. It requires the proof of intent. That's what knowingly means. So the prosecution has to prove intent, which is very, very difficult to prove. Monetary penalties also exist, as the slide shows, from $5,500 to $11,000 per claim trebled. So the dollars in these False Claims Act cases can run into the hundreds of millions and the billions of dollars very quickly.
What slide number are you on?
4.
Thank you.
Okay. Under the False Claims Act, each billing statement, the slide says UB92, which is the name of the billing statement, but basically each billing statement in a submission to CMS, which is the Center for Medicare, and that's who handles the payment of federal dollars. Each line item of claim is a separate claim subject to the penalties that I talked about a moment ago. And so examples of claims are where services were not provided at all, wrong provider is indicated, wrong time and location, wrong frequency, intensity, duration, incorrect symptoms and diagnosis, wrong supplies. I mean, it's basically a list of scams that have existed that have been integrated into this law. So under the False Claims Act, a party or organization preparing or filing a claim knew or should have known that they had actual knowledge of falsity of the claim, deliberate ignorance or of the falsity of the claim, or reckless disregard for the falsity of the claim. And I'll give you an example of that here in just a second. If it's a large organization that we're talking about that has committed violations of Federal Tort Claims Act, or that the federal government is alleging that they did, if that organization had a compliance program, meaning a place where they educated employees about the existence of these fraud laws and how they're applied and how the exposure of them in the hospital setting can be properly dealt with, just the existence of the compliance program goes a long way toward getting the institution off the hook. I don't know how many of you have heard of whistleblower claims, but they've been pretty prominent in the federal government. And in healthcare, the whistleblower is an employee who sees the company or the business or the hospital or the healthcare provider business like DaVita Dialysis, which is a good example, committing violations that they know are violations of the anti-kickback statute in the case of DaVita, and they go to the appropriate person at the company and say, this is against the law, and the company ignores that warning, then they go to the US attorney and say, DaVita is violating the anti-kickback statute in the way that it's doing partnerships with physicians. And the U.S. attorney says, thank you very much for that information, and prosecutes DaVita and gets a big damage award in favor of the government, the whistleblower can receive from 10 to 30% of the amount recovered plus attorney's fees. If so, there's a lot of money in these cases for whistleblowers that helps to police what's going on inside these companies that are violations of waste, fraud, and abuse. The anti-kickback law is a criminal statute like the False Claims Act is, which means that it's prosecuted by, in this case, the federal government, because it is a federal law. And the purpose is to control the influence of financial incentives on physician decision-making. So basically what it does is it prohibits offering, paying, soliciting, or receiving anything of value intended to induce referrals for services or items paid by a federal health program. And paid by a federal health program means Medicare, Medicaid. The anti-kickback statute applies to everyone. Actions must be knowing and willful. If you're going to prove a criminal violation, you've got to prove knowledge. Otherwise, you can't prove it. Intent is required. And that's a high bar. The violation of the anti-kickback statute is a felony under federal law, subject to fine of up to $25,000 and imprisonment up to 5 years for each count. And typically in these anti-kickback statute cases, there's hundreds of counts, so the money goes up big. For example, in the initial qui tam or whistleblower case heard against DaVita about 10 years ago, the amount of the monetary award to the government was approaching $500 million. The application of the anti-kickback statute is an art. You have to look at the facts of each case. They stand independently. It produces some big awards, but it takes a lot of labor to get there. So production-based compensation is an example of anti-kickback statute. For example, you go into you invest in an outpatient surgery center and you buy 10% of the stock of that outpatient surgery center. And then you go into the surgery center and you start doing surgeries, and you do cases representing 25% of the profits of the surgery center. If the surgery center pays you 25%, pays you a return on your investment equal to 25% of the profits of the surgery center, that's going to be a kickback. If the surgery center pays you based on 10% of the profits because you bought 10% ownership, that's legal. And that's one of the most common violations that, until enough cases were won by the federal government. But that case of production-based compensation was really common. I had some contact with it in representing some clients that almost got nabbed by the FBI for participation in surgery, actually a podiatric surgery center that was paying strictly based on production, paying dividends. Payments for recommending, payments for arranging, all of those are considered to be kickbacks. As is the case with all of these federal fraud statutes, remuneration or any important term gets defined very broadly because it's designed to catch, not to cull out. compensation, kickback, bribes, rebates, non-cash consideration like a brand new Suburban parked in your driveway on Christmas Eve. Those are kickbacks that are paid to induce referrals. Must be intended to induce referrals. And here's a fairly decent list of anti-kickback exceptions. And there's an awful lot of parties that are accused of paying kickbacks that plead these exceptions and lose. So the anti-kickback statute is complicated, it's vague, it's ambiguous, requires a facts and circumstances analysis on a case-by-case basis. Anybody involved in one of these cases needs competent legal advice. And you can't believe the scams. I had a doctor that found his way to me by referral from the Harris County Medical Society, who had been invited to join and participate in an investment in a medical service business like a curbside emergency room, sometimes referred to as a doc in the box. And all he had to do was to lend his Medicare number so that the business could get launched, and he would be in name only the medical director. Well, he agreed to do it. He was naive. He knew the person who had solicited him and had confidence in that person. And a few weeks after he first joined, he got some checks, which he was told were fee checks for providing medical directorship services to this business. And so he was happy with that until he was in his garage one evening not long thereafter, after dark, and had the light on and looked out and saw a black sedan pull up in front of his house and a couple of big guys get out of it and they walked up to him and reached in their inside coat pockets and flashed their badges, Federal Bureau of Investigation. And he had the presence of mind to say that he thought he needed a lawyer, and so they never interviewed him. But what happened was there was no business. What they were doing is using his Medicare number to dial for dollars. They were submitting 100% false claims that for services that were never rendered at all. And he had never been to where the facility was supposed to have been. It was nothing more than an address. There was no physical reality to it. And of course, what he didn't need was me as his lawyer, because I don't do criminal work and never have. But I was able to get him to a very significant white collar crime, which is what that's called, lawyer, who got him completely off. Had he accepted much more money, I think it would have been impossible. But that's why the high profile white collar lawyers are what they are. But that's how brazen these cases, the case involving this doctor eventually made it into the local newspapers, and the people that were perpetrating the scam were arrested and sent to prison. And so the law that's most commonly associated with healthcare waste, fraud, and abuse is the Stark Self-Referral Law, which prohibits referrals by physicians for certain designated health services to entities that the doctors have a financial relationship with, if there's no exception, if no exception applies. It's a civil statute. Nobody goes to jail for violating Stark, but it can be very, very expensive. No intent required, no criminal penalties, because it is a civil statute. Civil penalties up to $15,000 per referral. I don't have to tell you how quick those numbers can mount up. The reason it's called the Stark Law is not because of any condition of the law, but because the United States representative that first introduced it into legislation and shepherded the law all the way through its passage was a California congressman named Pete Stark. And the law has forever had his name. So this is a list, a partial list of the designated health services covered by the Stark Law. And in every list I've ever seen since the enactment of Stark, probably 25 to 30 years ago, clinical laboratory has always been at the top of the list. I think it's what Pete Stark was really after when he first got the law passed. In addition, excuse me, guys. No. Do I? I knew that was going to happen. Feel free to laugh. But I guess we all have our pets around when we're working from home like this. So this list is clinical laboratory, physical therapy, occupational therapy, radiology, MRI, CT scans, ultrasound, radiation therapy, DME.
I just, sorry to interrupt, but I think that the PowerPoint that you have up right now is not reflecting the slide you're on, at least what we can see. I see slide 6, which says like business organizations.
This is 16.
Yeah, I think you're sharing the slides from conference number 3.
Yeah. These slides are from conference 4.
We see conference 3 slides, origins of law, where it's on slide 6 and it says business organizations. At least that's what I'm seeing. Is anybody else seeing that?
That's where you left off on the last presentation, but you can find it in the contents folder.
Hang on.
I think it would be helpful if you can share the conference 4, because it's a little bit hard to follow by ourselves, I guess. Just kind of figuring out which slides are you at, if possible.
Yeah, that's what I'm looking for right now.
Thank you.
I thought I had them all lined up to be able to go through them seamlessly, but I guess not.
Okay, now we can see the slide 16.
Okay. I take no credit for getting it done, but I did. Shall I pick up from here?
Yeah, I had a quick question about this Stark Law. So this means if I own a clinic and let's say I can't refer people to LabCorp if we're in some sort of financial agreement. Is that what that means? I mean, if there's no financial agreement with them or any partnership, I can go ahead and tell patients to go to LabCorp. Is that right?
That's right. But if you own an interest in LabCorp, you can't.
Okay.
Hang on just a minute, guys.
I have a question, please, also regarding stock law. Is that okay?
Sure, I'm ready.
So what if I was in a rural area and I have a clinic and say an imaging center in a rural area? And I have to do imaging on, say, a few patients. Is that still considered stock law, or would that be considered an extension of my clinic?
It would be considered an extension of your clinic.
Okay.
And we're not talking about something like, let's say, half a dozen different doctors from different rural areas all buy a minority interest in an imaging center and then refer to that imaging center. That would be a Stark violation, because there is not an exception for imaging, but there is an exception for example, dialysis, for outpatient surgery. And there's also exceptions for underserved markets, grossly underserved markets. There's a matter of degrees. Bottom line is that it's very difficult to answer a Stark question unless you know all the facts and you go to somebody that specializes in giving Stark opinions, and you get an opinion of counsel that whatever the proposed activity is a violation of Stark or is not a violation of Stark. There's a whole section of the healthcare bar that does nothing but examine transactions from the standpoint of, do they violate waste, fraud, and abuse statutes, laws?
Okay. So in other words, before we buy into any businesses, we should make sure that we don't violate that law.
Absolutely. I mean, if you're
Awesome.
you're a cardiologist and somebody is proposing that you buy into a clinical laboratory, which happens every year like crazy, that is normally a Stark violation. And each time these promoters get rejected, they come back with another structure that this doesn't violate the law. The problem with it is that the Stark law is a very generalized law that is intended to cast a wide net.
Thank you.
Thank you.
I have a quick question.
Sure.
What about nonprofit organizations? You open a nonprofit clinic and you have a variety of different specialties in it, and some of the patients that come to you may or may not be able to go and seek care independently at hospitals, or can you refer them to your own nonprofit organization?
Well, generally speaking, you can refer without violating Stark to a service provider or testing agency or some type of business like that's part of your group. That's sort of an in office. For example, you're an orthopedist in an orthopedic surgery clinic that does feet, hands, total joints, sports medicine, knees, hips, and you get a patient that comes in to see you that you do hand surgery, and you refer them to a colleague in the office that does foot surgery. You can participate in the income from that case because it's in the same practice, in the same office, and that's an exception to what would otherwise be a Stark violation.
Oh. What I'm referring to is in an outside facility that is a nonprofit organization that you also own. So for example, you work for the school in academics and you have a patient that comes in for and complains of eye exam, and you want them to get care, but they don't have enough money to go get the care, but your own nonprofit organization has an eye clinic. Can you refer them to that eye clinic?
It's probably going to be a Stark violation.
Oh, I see. Even though it's nonprofit.
Yep, because it's not non-money. It's going to charge for its services. How does it get money?
Let's say donations and your own income.
There's no benefit to you in that?
Not from we wouldn't take money from the patients.
I mean, if it were done completely charitably, that might escape Stark. But to the extent that it gets examined, somebody's going to look at it very carefully to make sure that there's no benefits flowing to anyone that's in the referral network.
Excellent. Thank you very much.
Sure. Okay, can everybody see 17?
Yes.
Okay. This is just the list continued. The different designated health services, prosthetics, orthotics, prosthetic devices, home health, outpatient prescription drugs, inpatient and outpatient hospital services. But there are so many exceptions that it's unbelievable. So the financial relationship, as we've just been discussing, is ownership or investment interest, and then a compensation arrangement. Follow the money. Direct or indirect to physician or family member includes compensation for services, rent, royalties, licensing fees. You can do a landlord-tenant relationship, but the fee has got to be fair market value. It can't be some jacked up amount to cover a referral payment that is prohibited under Stark. Royalties, licensing fees, discounts on goods and services. And so here are the important exceptions for intergroup referrals, like the orthopedists that I was referring to a moment ago. In-office ancillary services, like if you have MRI capability in the orthopedic group practice, that's not a Stark violation. Ownership in large entities or certain rural providers, that's the underserved market exception. And some compensation arrangements, especially if fair market value. Again, you got to look at each of them individually. Then the last of the waste, fraud, and abuse laws that I want to talk about is Foreign Corrupt Practices Act. And basically what the Foreign Corrupt Practices Act says is that you cannot, as a United States citizen or entity, you can't go overseas and engage in behavior that would violate American law. For example, you can't go to certain countries overseas and pay bribes to the government to put your business in their country when to, for example, get a business opened, or a clinic or some kind of healthcare business opened up in a rural county in Texas, and you pay bribes to the city officials to get taxes suspended and to get beefed up business benefits. You can't bribe government officials In America, you can't bribe foreign government officials. That's what FCPA says. Fraud and abuse are government's #2 priority. And the laws are ambiguous, complicated, and constantly changing. Their application is uncertain. And as I was talking about earlier, corporate compliance programs, education of healthcare employees are the first and best line of defense from the institutional healthcare perspective. That is, hospitals or very large clinical organizations. Most hospitals and large clinical organizations do have compliance programs and have regular conferences and meetings and all manner of education available, self-study, classes, and requirements that employees attend a certain amount of this regulatory information education every year, and with third parties signing off on it. That's the end of the slides. I would have taken a break between 3 and 4, but we talked about that earlier. I hope that if you've gotten nothing else from what I've presented, I hope you've gotten the idea that it's worth your while when you're confronted by these questions that should I invest in this? Should I sign this contract? That you obtain the proper kind of help to guide you. Thank you all very much.
I actually had 2 questions.
I'm here for your questions as long as you have them.
One of them was pertaining to the true false questions that we had. And it was talking about if a doctor's distributions for his investment in a surgery center is based on the number of cases done, that is a violation of the anti-kickback statute. Is that true? And if so, I know that we had talked about earlier in the day when you're looking at compensation, as a young doctor, you're being compensated by a salary plus bonus. And then you said as you get older, it's kind of that,
eat what you kill.
Eat what you kill. Yeah. So is that, how do those two kind of?
Those two things are absolutely unrelated. One of them is the compensation for your regular services in the group and how you get paid for those services. And the other one is how you get profit distributions from an investment in a surgery center. The surgery center didn't hire you as an employee. You come to the surgery center as a physician, as a surgeon, to do surgery there. And the question is, when that surgery center totes up its balance sheet and profit and loss statement at the end of the year, it's highly profitable. And how does it distribute those profits? And the answer is, if it distributes those profits on the basis of ownership so that it's completely pro rata, and you own 2% of the surgery center and you get 2% of the profits, that's fine. If, on the other hand, that surgery center is distributing the profits based on production and you produced 10% of those profits, and therefore, even though you only owned 2% of the surgery center, you got 10% of the profits, at the risk of giving away the answer to that question, that is the answer. You cannot do that. That is a violation of the anti-kickback statute.
Okay, I see now that I understand the question a little bit better now. Thank you. And my other question was going back to what we talked about this morning and what you just said about, finding legal counsel for looking at contracts and stuff like that. How do we go about finding a lawyer who does healthcare law? I know, like, if you're looking for a cardiologist, you can get on American Board of Cardiologists, see who's board certified. But I know when I've looked at like lawyers in the past, you pull up their website and they specialize in a lot of things from, tenant law to, so is there some place you can go and look up if they're part of like a healthcare law organization or something like that?
There's 2 ways I would recommend doing it. And I think that they probably are pretty universal. First of all, if you're not if you don't have severe financial constraints, all of the large law firms in the country, but certainly locally, have health law sections. And you can get a lawyer at any of those large law firms. Another way of finding healthcare lawyers is through the medical society where you are. For example, in Houston, the Harris County Medical Society is a very active organization, and there are lawyers that advertise themselves to be healthcare lawyers. Yours truly is one, that are registered with the Harris County Medical Society and that are on their referral list. And I get referrals all year long from Harris County Medical Society.
Okay, well, thank you very much. I appreciate that.
I would submit to you that it's likely that there is a Dallas County Medical Society, a Bexar County Medical Society, a Travis County Medical Society, all of which do, among other things, act as a clearinghouse for matching up physicians with healthcare lawyers.
Okay, thank you very much.
Sure. Anybody else?
I have a question about the start law.
Okay.
So it's basically a scenario. What if I work for, or if I own two practices, one primary practice and the other specialty practice in a very rural area? So would that mean if I refer one of the patients that I would see in the primary care practice to the subspecialty, would that be a violation to the START law?
I don't think so, because I think your two practices that you're talking about probably are two offices, especially if you own both of them completely, and they're going to be considered a single unit. And so the referral you're talking about would be viewed more like an in-office referral.
Okay, I see. Thank you.
Sure. For those of you who have not been through tropical storms or hurricanes, pay attention to what the authorities say. There's no entertainment value. These are serious. And I want to wish each of you good luck, and hopefully the storm misses us.
Hopefully. Thank you very much for your informative lecture and preparing us for the future. Thank you for all the tips. Thank you.
You are more than welcome. Thanks again.
Bill?